Okay. Well, I can't see you on the Zoom screen. I see a few old, including old friends here. And it's wonderful to be here in Amsterdam. Thank you very much, Giovanna, for introducing me to that kind of introduction. Thank you, everyone. It's great to be in Amsterdam again. So this is the newest book that I've published, but it's the longest in terms of the amount of time that went into it. It probably involves around 20 years of work. And the world changed significantly while I was writing this book. So the title of the book is Emerging Powers in the World Trading System, the Past and Future of International Economic Law. And of course, we know we're in a period of crisis with respect to relative decline of the international economic order. And so the book addresses how did we got here. It's just to tell the story about starting this book. The book started really with the question of how could developing countries organize themselves to build legal capacity to advance their interests and protect their interests in a world trading system where the rules were mainly developed and mirrored those within the United States and European Union, and where most of the sort of most experienced lawyers, both within government and in private law firms, were based here in the United States. And so the question is, how would other countries really, would you just see this as a new form of power? Here is a form of legal power in which other countries would not. The United States would, in other words, rule through rules. As opposed to just rule through coercion. But obviously the world changed significantly. And so the book addresses the paradox as to why it's the United States, which has become the revisionist power, so upset with the constraints of the rules of the system that it created, and other countries, in particular China, but Brazil, India, which complained that the rules were rigged against them, now have become defenders of the overall system. And so that's a paradox. And all actually international relations theories in sociology, from the realists to the institutionalists, to people like Bourdieu, always say, recognize that within legal orders, there will be distributional effects. But all of their predictions, you could sort of quote them as that the rising powers which will try to upend the legal order, and the incumbent powers will try to conserve it. And so why do we face this situation today? In the book, it's multi-method, predominantly qualitative approach, involving 3 extended case studies of Brazil, India, and China, and in relation to the trade system. It involves over 200 interviews, combined with a survey, descriptive statistics, participant observation, being in Geneva, actually seated at the World Trade Organization, having an office there. So getting a sense of the feel of the negotiations and of the culture, the institutional culture of the place. And given that this involves China, Brazil, and India, in each case I worked with an academic there who was very networked into sort of the trade law expertise within that country. So Michel Raton Sanchez Badin in Brazil, who works at FGD, but very much they were training government bureaucrats, working with government, and her husband actually was, a minister in the government, Gilba, and so very connected to within this networks, the international economic law networks. And in India, I worked with James Nadupra, who actually was part of a UK and UN almost a decade-long program to build legal capacity in India on international economic law, and now heads a government think tank. And in China, Henry Gao. who participates in WeChat forums with members of the Department of Ministry of Commerce and so forth in terms of strategies and understanding. So here's the paradox, and this is John Eikenberry's book, Liberal Leviathan, where from an institutional accounting, he calls sort of the rules-based international law system a new constitutional settlement, asking, what do great powers do after they win wars? So after World War II with the GATT, after the end of the Cold War with the World Trade Organization, is that they institutionalize the rules that they want so that they rule the rules. So that's the argument. And of course, here we have the US unraveling of the world trading system. So the question is, what explains it? We get different narrative explanations, and predominantly you see them coming from economics, political science, at least in terms of trade, in the disciplines that dominate this study. And in economics, Richard Baldwin and others talked about the rise of global supply chains, with a combination of G7 know-how or US and European know-how with Chinese labor or Asian labor, which then resulted in the shift in manufacturing to Asia. And so that would explain sort of this, why China would become a manufacturing superpower, enable India to increase in terms of becoming a power in services. And because of the growth of India and China in particular, this served Brazil very well in terms of its agribusiness, its export of all the raw materials needed to these economies, particularly the Chinese economy. And as a result, you see this massive growth of GDP in China and India, less so in Brazil, clearly facing its own crisis now. But the graph on top is purchasing power parity, where China is in orange or red, and US in blue, so it's already surpassed it. In green is the three countries together. If you look in the lower portion, China is then rapidly closing the gap in terms of nominal GDP. It will, is predicted to surpass the US nominal GDP in the next decade. So what about law, right? Law, especially to take from Eikenberry, it's not as if law is simply epiphenomenal. Countries, invest a huge amount of resources in developing law. And so the book looks at law as a medium, legal capacity as a medium for them to try to institutionalize forms of legal authority, which will advance their particular goals. And so that's the central question of the book then becomes, how has the international trade and broader economic legal order changed since the WTO's creation in 2005, because of Brazil's, India's, and China's rise in the development of what the book theorizes as trade law capacity. And it breaks the question down into three questions, which is first, the way the book, in a sense, started, the research started, how did they build legal capacity? Legal capacity is something which I'll define in the next slide and also address why it matters. But it's not free. It's not something just natural out there. It involves a great deal of specialization, professionalization, both within government and more broadly in the private sector. In doing that and developing this expertise, they actually also significantly transformed themselves institutionally. And so a lot of the book was tied into what I refer to is seeing international law as part of transnational legal ordering, which deeply becomes implicated within states and has affected in multiple different ways sort of the role and place of law within these countries, is particularly international economic law. And then the third question, of course, which became quite salient and apparent as the US suddenly felt that the World Trade Organization was no longer serving its interests, was what sort of implications did this investment in trade law capacity have for the trade legal order itself? And so this builds from a series of probably 4 books now, looking at developing a theoretical framework, transnational legal order theory. Transnational legal ordering, this is slide notes refers to the processes through which legal norms are constructed, flow, settle, and unsettle transnationally across levels of social organization. So just what becomes in the mindsets of officials and enterprises, professors, think tanks in terms of how does customs law work? How does import relief law work? What tariffs are? Is liberalization a good thing or a bad thing? What's the role of standard setting agencies, standard setting expertise? What's the role of courts, judiciary, and so forth? All of those sort of norms, patterns, behavior become imbricated. And in that sense, the WTO is incredibly successful, the book shows, in terms of having significant sort of knowledge effects within these and effects of creating incentives to invest in certain forms of expertise amongst the professional classes of these countries. And the result of these processes, the argument is, can give rise to one or more transnational legal orders. The concept refers to a collection of formalized legal norms and associated organizations and actors that authoritatively organize the understanding and practice of law across national jurisdictions. So just to take intellectual property, for example, in China, they created whole new patent agencies, patent bureaucracies, patent examiners, professionals, patent competition, teaching patent law, and law schools, institutes. There's now more litigation involving intellectual property in China. I think it's 5 or 10-fold more so than in the United States and Europe. Most of that litigation is actually Chinese to Chinese. And involves, if you talk to actually, even though the United States and others complain that China's not advanced as far as it has in terms of intellectual property protection, it's a revolution in terms of sort of the way intellectual property is viewed in that country, but also in India and Brazil. These are both involved contests within these countries between different interest groups or those with different ideological frameworks. But in India now, officials say that the word for the major Indian pharmaceutical companies is patent or perish. And that certainly, it was like patents and perish, right? Was what the discourse was in the early 1990s when the TRIPS was being negotiated. So I define trade law capacity broadly as the ability of a country through harnessing resources to use law to defend and advance its international domestic trade and trade implicated policies. Trade law capacity reflects a form of capital or power to advance interests in this contested transnational legal field, that of trade law. And the concept has equivalents in other disciplines, as it constitutes a form of power for political scientists and an incentive-driven investment for economists. So here are 9 different ways that trade law capacity matters. I mean, clearly it matters in terms of the drafting and the negotiation of international trade rules. Language really matters. Coming up with negotiating modalities is incredibly complex. And the first time that any country, sort of developing countries in particular, was led by Brazil and India, came up with negotiating modalities, which had a major impact on negotiations, was in 2003 at the meeting in Cancun, when they came up with new negotiating modalities for agricultural negotiations. And they upset the negotiating modalities that had been advanced by the United States and European Union. These were developed primarily by a think tank in Brazil, funded by Brazilian agribusiness. But they had to work very closely with the Indians, because the Indians, are much more protectionist, much more concerned about small-scale agriculture in India, potential uprisings in the countryside, as there have been against the Modi government if farmers get upset. And so they came up with negotiating modalities which advanced both of their interests, and China signed on. And that was a major sort of moment in the WTO to negotiate the negotiating dynamics which had carried on throughout the 2000s. Monitoring of foreign compliance with commitments. You can't just hire sort of outside law firms in Brussels or Washington, D.C. You really need to sort of know, be able to identify violations in the first place. And so you need to work with the private sector, which often, has to have a sense that, oh, we're involving a trade problem, and this involves a violation of an international legal obligation. So that's it's sort of a form of diffused legal capacity to identify a problem in the first place. Clearly, to bring complaints successfully in specific cases, given the complexity of WTO jurisprudence, the complexity of WTO rules, the fact that just the jurisprudence alone is almost 100,000 pages in the first 25 years of the WTO, as well as just the complexity of the text. Shaping terms of trade effects, so those with large market power can devise trade policy in ways that has terms of trade effects that benefit them at others' expense. It shapes the interpretation, application, social understanding of the law over time, shaping the meaning of obligations. You can see legal text involving actually, a construction of meaning, which then becomes settled or not, but they actually involve a battle over the text. So those who can participate could shape arguments for the interpretation of legal text in particular ways, can define what the law means over time. And this is one of the great complaints for those who find that the WTO is unbalanced, because there's been fewer development through a legislative or rule-making process, through political negotiations. But that means that basically there's a delegation of power to legal authorities, and those who can wield the legal authority, the authority to persuade regarding the meaning of text, have a great impact on not only the meaning of those texts, but also on future negotiations. So, for example, when Brazil won the famous cotton and sugar cases respectively against the United States and European Union, that in a sense removed certain issues from the bargaining table, because they had now become a settled understanding in terms of what the existing law meant. Same true with the famous zeroing cases, which so upset the US that found that zeroing is illegal under the anti-dumping agreement, or that the definition of a public body for the purposes of the agreement on subsidies and countervailing measures, that these could be subject to negotiation. In fact, the United States position was we actually understand what we had negotiated, but clearly other members of the World Trade Organization had other views, and the U.S. lost that interpretive contest before the WTO appellate body and certain panels. Bargaining in the shadow of the law, it matters not only in terms of just enhancing your bargaining leverage when you have a dispute that you have the capacity to bring and to win the case, but it affects the strategic pursuit of settlement. You can think of litigation as sense and practice as litigation. It involves both litigation and negotiation simultaneously. Protecting domestic policy space for developmental and regulatory initiatives. So as countries became more sophisticated, so for Brazil, for example, faced a major challenge in our case with respect to its industrial policy. There were a great deal of sort of battling expertise amongst different members of Brazil's private sector and different government ministries in terms of how is this going to affect Brazilian internal domestic policy, and how could you do so? Either how could you use WTO law to sort of combat the Dilma government on the one hand, or how could you use sort of arguments that this complies with WTO law in order to tailor your policies in ways to ward off challenges. Also, warding off capture by protectionist sectors. Protectionist sectors are always asking for relief, and so government gives them sort of leverage to simply say, "Oh, we can't do this. And we can't do this not because of our own political will, but rather because we are compliant with international law." And the United States uses this, as well as the European Union uses this, as well as any country. So all of these countries, their ministers, especially their trade ministers, since are Janus-based, they're looking both externally at what our other countries were closing their markets to your country's exports, but also internally in terms of compliance or how to use WTO law for their own strategic purposes. And triggering spillover effects. This is major in China. I mean, the interviewees in China, a lawyer like general counsel for state-owned enterprises and everything, which didn't have any lawyers inside them before. So this just has changed our complete mentality about the role of law, how to contract, and so forth. And WTO had major implications. So it's not easy to develop legal capacity. It involves huge investments in expertise, it involves financial resources, it involves politics, and it involves clearly domestic governance. This you can have capture and so forth. Book goes into this, but basically it involves greater professionalization of a trade bureaucracy, coordination amongst ministries, which is a huge challenge for many countries. Ministries actually getting them to talk to each other in order to come up with a common position. Or actually for China, you heard this all the time, it's a way to discipline different ministries, right? And enhance power of certain ministries in relation to other ministries. Coverage in the media. In Brazil, for example, when in the height of the sort of the impact of the WTO, presidential candidates would compete over who won more WTO cases, and you see this in the major Brazilian papers in China. Major coverage in the media. So this became popularized in terms of just knowledge of what the WTO meant. The Communist Party put so much intense information to persuade those within the country that this was good for China. And there's a whole books written about how this actually shifted the Chinese conceptualization of what sovereignty meant in the realm of trade law. Not obviously with respect to the law of the sea or other areas, but with respect to trade law, because it's advanced China's export interests in terms of for its greater strategies. Changes in academia, courses with courts, role of lawyers in trade, the private bar developed significantly in these countries with respect to trade law. Changes in the private sector, hiring lawyers, in-house counsel, especially including for IP, for example, think tanks, and developing public-private partnerships. So from the perspective of transnational legal order, you can see this along different dimensions. Clearly, China changed apparently over 3,000 laws. I mean, it was, compared to what the United States and the European Union had to do to adapt to joining this organization, it was an immense change in their legal and institutional systems, creating new ministries, new departments, and so forth. Changes the boundary of the state and the market. Clearly, there's a liberalization focus of the WTO, but at the same time, to develop this sort of legal capacity of the growth of the administrative state in many different areas. The allocation of authority amongst different institutions, between the central government and the regions. India, this is very important. Changes in China is actually, the central authority tries to use the WTO to enhance its authority vis-a-vis the provinces. Changes in expertise, the role of expertise in governance, and associational patterns. So this is a very networked world. And so basically the core of the book is the case studies of how this took place in Brazil, India, and then 2 chapters on China. So here's China negotiating, sweeping legal changes. They actually created a ministry for the cleanup of laws. And it's unattachable to the United States to sign an international treaty, and then create a new department as a department, not a ministry, within the ministry for the review of all laws, right? To see which ones need to be abolished, which ones need to be revised, which ones needed to be reenacted after certain changes, and so forth. And that was all done within the Ministry of Commerce, which is sort of the external face towards the WTO. And many refer to this as a change of the Chinese constitution. In fact, that's a quote from Tom Ginsburg, who I guess will be here next week. The sweeping legal changes in this is the court and intellectual property courts, or a combination of a Greek temple or Roman temple, right, with Chinese characteristics. Thousands of seminars. When I started at Wisconsin, actually, they brought Chinese judges to be trained in Wisconsin in law. I was asked to teach about WTO law. I go, why would you want, these are local judges, right? And they say, oh, no, they really want this, right? This is what they really want. They want to learn WTO law. You have popular books about, people, just travel writers and New Yorker writers, interviewing people in far-flung places in China, and they bring up the WTO in conversation. That more books were published in WTO in China by the rest of the world combined. 2/3 of all research projects between 2007 and 2014 funded by the state-run international economic law in China. They created new moot courts. These are sort of like the best students in China, right? Where then compete, and then they would use these moot. This is the first moot court competition in China, and it's on WTO law. And then the Chinese state and big law firms, up to 1,000 lawyers, right, would then use this for their recruiting device to the best of the best. You have new law firms, mega law firms, and they're basically building. This was my first book in the WTO, which really focused on how the United States and Europe created public-private partnerships between the private sector, law firms, and the government legal services in Europe and USTR in the United States to prevail. And they actually, how did they strategize in terms of litigation to use WTO law to advance their interests? Of course, they did so very well at the beginning. They still do so very well. They still do so better than anybody else. But the fact is that China, Brazil, and India became much better. You have capacity building in law firms, anti-dumping bar. Here's Huawei with 200 at least, maybe probably over 300 now, in-house lawyers. This is Itamaraty in Brazil. You have professionalization in the ministries, these trade associations, elite law firms, academia. Here's Brazil, sort of famous Embraer case, followed by a patent case. In all three countries, the same pattern. They were first on the defensive. And being on the defensive was a wake-up call for the need to build legal capacity if they were going to be a player within this new system. Brazil developed sort of, this is Brazil's language, not mine. Three-pillar model, just involving Brazil, the capital, Geneva, and all the private sector firms, and this information flows, and all the different players. Sometimes they would use, for example, a foreign law firm in the Embraer case, but then they would use local Brazilian law firms who actually were networked with US, Washington, DC based firms. This was a common story. A lot of sort of transnational movement and training also, maybe studied here at the University of Amsterdam. As third parties, here they had, Brazil created an internship in Geneva where they'd actually bring people from other ministries and people from the private sector and people from law, PhD students in law, be able to go to Geneva, go to meetings as part of the Brazilian delegation. The two largest delegations usually took meetings with Brazilian and Chinese delegations, because they had so many. Chinese also flew in academics, right? And ministry officials, basically to train the ministry officials about why WTO law mattered, why they had to pay attention to this. And so the question is, what sort of impact did this have on states? And it clearly, it involved the strengthening of the state, is the argument of the book, not the weakening of the state, but actually see enhancement of different state administrations. I used Peter Evans, who wrote a famous book about embedded autonomy, about the industrial transformation of Asian states, as sort of a metaphor. You can think about legal capacity as a form of infrastructure within a country. And to develop that infrastructure, you had to have it in the public sector, otherwise it would just be subject to capture. But the public sector's hand was strengthened through diffusing expertise broadly within law firms, within companies and so forth. You saw this, each country did this in a different way, because obviously these are very different countries in terms of the relationship between the state and the private sector. So Brazilian law firms, they sued their own government to force it to hire them, right? That's obviously impossible in China. No law firm would ever think of doing that, right? They'd be like other human rights lawyers, their life would become more difficult. But they each, you see these common patterns, right, of how they diffuse expertise, even in China. You saw the first time independent trade associations develop in China. Like at steel fasteners, where they'd have problems in Europe, which was the famous case on steel fasteners. So the private sector, the government, they all work together with law firms, both Chinese and US law firms. This obviously had indirect effects, right? So part of the story of this book is not only how they directly affected the WTO and by developing legal capacity, but transnational legal ordering also has unexpected effects, indirect unexpected effects. Clearly, the unexpected effect was bringing China into the WTO would destroy the WTO, or in terms of those who were advocating, who mainly were, trade liberals in the United States, bringing China to the WTO. And that was the indirect effect was what I call in the book, a double-edged shift in inequality, where both you had the rise of the rise of inequality, especially most saliently in the United States, which then created space for a populist, nationalist, reactionary election of Donald Trump. But you also have a decline of inequality between the United States, China, India. And so suddenly Americans are being outcompeted by Chinese, by Indians in services, by Brazilians in agriculture. Clearly, this then must involve, quote, cheating. Somehow they were not playing by what we call the rules-based system, which is a term of art the United States uses instead of international law, right? This is the rules-based legal order. This is to quote Graham Allison, at least for most of the world, what that means is we make the rules and you obey the orders, as opposed to an international legal order in which you have a third-party dispute settlement where a neutral third party will determine how to interpret the rules. And so you can think about this being shaped in at least three ways, sort of this transnational legal order for trade. One, I think clearly they were able to engage in negotiations. And this not only, there's been lots of text written on this. Some of it is sort of this idea of the special special and differential treatment that developing countries get, and this no longer work, and with the rise of China. But the U.S. actually it's more complicated than that, because the U.S. is actually asking China to catch up. And if the core negotiating norm principle in the WTO is reciprocity, it's actually reciprocity isn't good enough anymore, because China's tariffs are higher than the United States. In the US, the redefinition that Lighthizer and Trump and others were trying to determine that reciprocity was not negotiating from the status quo now, but reciprocity in terms of you got to lower your tariffs much lower than we need to lower our tariffs. And this came up in 2008 when the sectoral negotiations for key sectorals, including chemicals. The US tried to press China, Brazil, and India to reduce their tariff to 0%. In these key sectors, and they simply said no. They said, first of all, this is called the Doha development round. We're supposed to get special and differential treatment. But second of all, this is a breach of the principle of reciprocity. In terms of the demise of binding dispute settlement, clearly, we're still seeing whether or not this is terminal, right, in terms of the appellate body, or will the Biden administration actually come up with a proposal. So far, it looks like it's terminal, but we will see. And then finally, you see a fragmentation of the trade law system. The Obama administration's strategy was to develop new regional orders and to potentially combine them into a mega organization. So we had TTIP on the one hand and TPP on the other. But of course, China and Brazil and India also have become very active in negotiating new both investment and trade agreements. China having signed more investment agreements than any country in the world besides Germany. And China, of course, now petitioning to join the CPTPP, and having recently signed and concluded the RCEP in Asia. So you see a much more complex ecology. It's not like transnational legal ordering has disappeared. It's just I call it an ecology now, where the World Trade Organization is not as centralized an order as it was. Right? It's become a much more complex order. Which raises the question, what about trade law capacity going forward? Paradoxically, their investment helped catalyze the potential collapse of a centralized multilateral trading regime, that's dispute settlement system. So what's the benefit going forward? on the one hand, you do see a changed logic, right? Trade law is becoming more like arms control, in which you still have treaties, arms control treaties, you still trust and verify, but you don't have this sort of the public good of a neutral third party dispute settlement system to interpret the rules. Rather, you have different sides claiming the others, in terms of lawfare, pointing the finger at others, saying this is a breach of the rules. And we think we're moving into that area. But nonetheless, we see continuation of bilateral deals, regional deals. You see sort of pointing to the rules unilaterally, but at the same time, tit for tat responses, also pointing to the rules. And so the challenge is, what will be the role for the multilateral system within this much more complex ecology of trade law? And so I'm going to end there. I mean, why not just say in terms of where do we go forward? This is a new article that just came out last month in the American Journal of International Law 9. So typologizing sort of different approaches. One is we need more rules to constrain the state, which I sort of a shift to sort of embedded neoliberalism. Control, the discipline state-owned enterprises, state subsidies, and so forth. But obviously that's complex, given the new knowledge economy in the United States wanting to subsidize its own semiconductor sector and so forth. The second is where we are now, sort of this form of power-based bargaining, which is continuing. And the third is, could you have a pragmatic rebalancing within a multilateral framework, which that article puts forth. I can explain, if you want to discuss that, how to move in that direction. But maybe I'll just conclude in terms of the theorizing more broadly. One, this exemplifies the book, both the demands and the payoffs of looking at both at the international level and at the national level concomitantly to see how they recursively implicate each other. So the WTO had major impacts in these three countries, but these three countries' development of law clearly implicated the meaning of law and sort of this broader, the development of this ecology of transnational legal order for international economic law itself. And most countries, there's obviously a huge amount of study in the European Union of the impact of the EU within member states of the EU and the contentious politics of that. There's much less study of the impact of international law within countries such as Brazil, India, and China, much less a comparative study. And so this book tries to do that comparative study with respect to these three big powers. I mentioned the indirect effects, right? It's the unintended consequences of transnational legal order. It's not just a sort of a predictable path involving path dependencies, right? It can have these unintended effects, which would lead to not only the settlement of legal norms, but also their unsettlement. That's what we see. And that's the major challenge of our time with China's rise. So thanks so much. That's the book. And if people have questions, comments, or want to discuss anything in particular, I'm all yours.